What if I told you that one of the biggest mistakes creatives make isn't being copied? It's giving away their rights too cheaply, or worse, entirely. Because most people don't realise this. You don't need to sell your intellectual property to make money from it. You can license it. And that's where things can get really powerful. Hello and welcome back to Elise Explains IP, the podcast where we break down intellectual property into practical, real-world strategies for business owners, creatives, and advisors. Today's episode is all about how to license your creative work, what that actually means, how it works in practice, and how to avoid the common traps that can quietly cost you control over what you have created. This is a common concept in software licensing, but it's not widely accepted in many creative arts. So, what does licensing actually mean? When you create something, whether it's a brand, a logo, a photograph or an artwork, maybe it's a course or some software or written content, you automatically own the copyright in most cases, subject to, as we've discussed, any sort of contractual agreements. That ownership gives you a bundle of rights, including the right to use it, reproduce it, adapt it, and importantly, allow others to use it. A license is simply permission. You're saying, you can use my work, but on my terms. And crucially, you still own the IP. You're just granting controlled access to it. So why is licensing so powerful? From a commercial perspective, licensing, particularly in creative arts, is often underused. Which is sad because it allows you to generate ongoing revenue, expand your reach without doing more work, retain long-term ownership, and build more scalable business models. Think about it. Some photographers license images to brands or to image databanks, designers licensing their patents to a fashion label, or course creators licensing content to various educational institutions, and software companies, as we sort of discussed, licensing their platforms instead of selling them. You're not trading ownership for a one-off fee. You're creating a recurring or leveraged income stream. And here's where things start to go wrong. Most creatives are already licensing their work. They just don't realise it. For example, that text message you sent that said, sure, you can use that logo. Yeah, go ahead and post that image. Or you can use this in your marketing. There's no contract, no scope, no boundaries. This creates legal ambiguity. And as we've talked about endlessly, ambiguity is where disputes live. Let's take a common scenario. A freelance designer creates a logo for a small business. There's no written agreement, just an invoice. The client assumes I paid for it, so I own it, which could be correct. The designer also assumes I created it, so I own it, which again could also be correct. Then the business expands internationally, they modify the logo, and then they sell up. It's an equity event. Now the question becomes, who actually owns the IP and who had the right to do what with it? Without clear licensing terms, this becomes messy and can become expensive. So if you are licensing your work, here are a few variables that really matter. Number one, scope of use. What can they actually do with what you've created? Can it be used only online or in print? Can it be commercial use, internal use? You need to be specific about the use cases. Number two is exclusivity. Is the license exclusive to that client so that only they can use it? Or is it non-exclusive so that you can license it to other people? Because this is going to dramatically affect the value of what you are selling. Number three, duration. How long can it be used for? 3 months? 12 months? Forever? Perpetual licenses should be priced very differently from a short-term use. And four, territory. Where can they use it? Only in Australia? Globally? This becomes critical for scaling businesses. And finally, modification rights. Can they change your work? This is often overlooked and can impact brand integrity, reputation, and moral rights, especially for creatives. Another thing you might want to think about is how they're going to pay for this. It doesn't have to be a one-size-fits-all approach. You can use a combination of upfront fees, royalties, perhaps subscription-based payments, or usage-based pricing. And this is where licensing becomes a strategic commercial tool, not just a legal document. So, What are some of the biggest mistakes that people make? Let's call these out clearly. Mistake number 1, assigning instead of licensing. You sell the IP entirely, often without realizing the long-term value. You should always have a conversation when you're being engaged to create something about what that is going to be valued by the business at in the future. Mistake number 2 is not having written terms. Handshake deals create uncertainty, and they usually favour the party using the work. Mistake number 3, being too broad, granting unlimited use forever, globally, for a modest fee. Mistake number 4, not thinking about the future. So what happens if the client scales, the work becomes central to their brand, and they later exit their business? Licensing needs to anticipate growth. Here's the shift that I encourage clients to make. Stop thinking, what is this worth today? Start thinking, what role could this piece play in someone's business over time? Because that's what you're really pricing. If you're currently creating and sharing work, here's where to start. Audit what you're licensing already. Look at your client work, your collaborations, and content usage. You may already be granting rights informally. 2, decide your default position. For example, do you want to retain ownership as a standard? When, if ever, do you assign IP? Make this a conscious business decision. 3, create simple licensing terms. You don't need a 40-page agreement. Even a clear, structured set of terms and conditions covering the scope, duration, payment, and usage will significantly reduce risk. 4, price based on value, not effort. A logo used on a small local business, as opposed to one used for a national brand, should not be priced the same. 5, get advice before big deals, particularly where exclusivity is involved. The license could be perpetual, or the work is core to someone's business. This is where small decisions can have long-term consequences. Licensing is one of the most powerful and underutilized tools in intellectual property. Done properly, it allows you to keep control, build recurring income, and scale your creative work beyond your own time. We've talked about how it works for technology contracts. Now we're talking about it in creative spaces. You need to think about how it might apply to whatever business you're putting together. Done poorly, it can quietly transfer value away from you and your business. If you're not sure whether you're licensing, assigning, or unintentionally giving away rights, that's exactly the kind of thing we unpack in a strategy session. You can book one via my website, and we can map out together what you own, how it's being used, and how to structure it properly going forward. Thanks for spending time with me on Elise Explains IP. If you picked up something useful, hit follow, subscribe, leave us a review, or send it to a founder friend who could use this information. And remember, this is general information, not legal advice. If you do want help with your IP, you can book a strategy call with me at any time via my website. The link's in the description. So until next time, own your own ideas.